Hello everybody and welcome to the first lesson of a series of videos looking at the European Convention on Human Rights. What we're going to do in this video is just simply take an introduction to the ECHR, the context of the ECHR from which it was developed, of course coming out of the end of the Second World War, and then what we're also going to do is outline the scope of this series of videos. So this is going to be fundamentally a series of lessons looking at the fundamental aspects, a substantive series on the fundamental aspects of the ECHR, the European Convention on Human Rights. We're going to examine, like I said, its history in this video, talking about where it comes from, and then, like I said, outlining the scope of this series of videos. Now, one of the things that's very important to note is that what we're going to do in this series of videos, as I'm going to mention towards the end of this lesson, is talk both about the substantive law of the ECHR, the substantive legal principles, the various different rights that are protected, and the jurisprudence and treaty provisions which seek to protect them, as well as the procedural elements of the ECHR. We've got to think about the ways in which the court is structured, the ways in which cases are brought to the ECHR, and the ways in which precedent is established in the ECHR. So this is really a dual-purpose series of lessons, talking firstly about some of the introductory issues, and then we will get on to the substantive law, and then finishing by thinking about how the law of the European Convention on Human Rights is actually enforced, and actually how cases are brought to the ECHR itself. So beginning first then, let's think about what the history of the ECHR tells us. The ECHR, of course, standing for the European Convention on Human Rights, is adopted following the end of the Second World War in 1945. Now, the convention itself isn't adopted until 1950, but it was in 1945 that we see the end of the Second World War. So, World War II ends in 1945. It ends in Europe in 1945 in May. And then we start to see the creation of a number of different elements of international law for the protection of human rights. In fact, one of the things that's quite interesting as a critique from the perspective of somebody who is doing history of international law is that you can see the kinds of provisions, the kinds of treaties, the kinds of obligations, and the kinds of commitments that are at least ascribed to at the end of the Second World War. But then you see a major gap between those commitments on paper and then the actual implementation of those commitments in law itself. So one of the things that's quite interesting is that at the end of the Second World War, we see things like the adoption of the ECHR. We see things like, of course, the establishment of the United Nations. We see a brand new set of Geneva Conventions. We also see the Universal Declaration. And what is interesting specifically about the Universal Declaration is that you sort of have what is not a binding piece of international law outline a number of different rights that are to be established in international law, and then quite a significant period of time goes until we start to see the true international treaties in the 1970s, that things like the political covenant, for example, or and treaties of that kind of nature, that actually enshrine those principles. So it's all well and good establishing all of these new rules and all of these new ideas and all these new principles of international law, which is what we do see at the end of World War II. We, of course, see just an explosion of international law from all parts of the world, all different elements of international law, and then the actual effective implementation of those rules are a little bit more questionable. But one of the areas that it is not the case where this happened is in the course of the Convention on Human Rights, the European Convention. The European community at the end of the Second World War establishes something known as the Council of Europe. And the main viewpoint here was that there was needed to exist a certain human rights convention, the idea being that human rights conventions would be able to prevent the gross human rights violations which take place at the end, or during, should I say, the Second World War itself. Of course, at the end of 1945, there is not only the kinds of war crimes that were committed in the day-to-day battles and the day-to-day conflict itself, but then there was also the shadow of the Holocaust, which was just sort of elusive throughout the entire period of European history. It was probably the darkest point in all of European history. And so the reality here is that there is this need to create some kind of convention, to create some kind of international obligation that all states to and as part of the European community are going to adhere to essentially establish the prevention of any kind of gross human rights violations of this nature. And fundamentally, if we think about what is going on today and what has happened since the end of the Second World War, we are in something of a long peace. There are definitely conflicts going on at the time of recording. Of course, we still have the Russian invasion of Ukraine, the largest international military conflict since Vietnam, I believe. Or even maybe definitely in Europe since the end of the Second World War. We of course had things like the atrocities that were committed in the breakup of the former Yugoslavia, and there are of course other different conflicts that are going on around the world. But for the most part, nothing on the scale of the Holocaust has ever happened since the end of the Second World War, which could partially be down to the fact that we have so many international conventions and the establishment of international law in this kind of way. If there was a general public commitment to establish an international human rights regime, then we can better protect those rights within Europe. That's fundamentally what the purpose of the Council of Europe and the purpose of the European Convention fundamentally is. In a similar way that the European Union is established, or at least was established, out of a general commitment that conflict between European states would be less likely to happen if there is a merging of economic relations between those states, which of course is the case. It would also be seen that the ECHR could distance Western European countries from the communist Eastern Bloc at the beginning of the new Cold War. So almost immediately after the end of the war, of the Second World War, World War II, in fact, during the Second World War itself, in fact, there was this beginnings of a new conflict that became known as the Cold War between East and West, between ideological commitments to capitalism versus communism. And you can contextualize the creation of the ECHR within this broader conversation as something to do with and in conjunction with this idea of there being a newly established Cold War that begins to take shape towards the end of the Second World War, and then it starts to really ramp up into, as we go into sort of 1947, 48, and into the 1950s. So, as mentioned at the start of this video, this lesson, we're going to be taking a substantive overview to the law of the European Convention on Human Rights. We're going to be examining the ECHR, the ECTHR, the court itself, from both the procedural perspective as well as in terms of the specific human rights protections that it offers. We won't cover every single human rights protection because not only do we have the convention itself, but we also have the addition of a number of other protocols which further enshrine other rights. We're just going to focus on the ones that are the most important, or at least the ones that really have the most substantial amount of law attached to it. But in doing so, we're still going to be covering a substantial number of different rights. I would encourage anybody who is following these lessons as well to have a copy of the European Convention on Human Rights at hand, available to them as you are following along with these lessons. All you need to do is just type in onto Google the ECHR, and there's a PDF copy there available for free. So too are there PDF copies available for all of the additional protocols that can exist as well. Just as a general way of having an understanding of what the convention says and where it says it. I will be citing the convention, of course, at multiple stages for multiple points throughout this series of videos as well as citing case law of the same effect. So this is what the series is going to look like. We're going to just begin with the first few lessons looking at some introductory elements. So we're going to talk about the history of the ECHR, we'll talk about the history of the Council of Europe, we'll talk about what the Council of Europe actually is, the difference between the Council of Europe and the European Union, for example. We'll talk a little bit about the procedural elements which relates to the European Court of Human Rights, the ECTHR, but we're going to spend a little bit of time talking about the kind of enforcement mechanisms as well in this kind of introductory bit, but then we're also going to come back to this in more detail at the end of this series, because the middle part of this series is going to concern the various different rights that are under protection under the European Convention. We'll begin first with the right to life, which is part of Article 2 of the European Convention. Freedom from torture and inhumane treatment, which is part of Article 3 of the European Convention. the right to liberty and security of person, which is part of Article 5 of the European Convention, the right to respect for family and private life, part of Article 8, freedom of expression, which is established in Article 10, and then freedom of assembly and association, which is established in Article 11. So, like I've mentioned, there are other ones that exist that we can talk about, but fundamentally we're going to be spending about 5 or 6 lessons on each of these individual provisions and protections. So we're going to be really talking about quite a substantive amount of human rights law in that regard. And then finally, like I said, we're going to spend some time talking about the enforcement process, how a case is brought to the European Court itself, how precedent is established, and again, some of the more procedural elements of the court itself.